So the goal of this presentation is to give you an overview of some aspects of disability in education, to give you an idea of how those two are linked to one another. There's a lot more to be said about this subject. As I said, this is just going to be kind of an introductory lecture. We'll begin with a little bit of context here. So in 2019 to 20, which was the latest data that I could find, the number of students ages 3 through 21, so that's basically kindergarten through college, who received special education services under the Individuals with Disability Education Act, which we'll go over in a little bit, was 7.3 million. That is 14% of all public school students. And of those, 33% had what are called specific learning disabilities. And that's essentially defined as disorders in one or more of the basic psychological processes involved in understanding or using language, which disorder may manifest in the imperfect ability to listen, think, speak, read, write, spell, or do mathematical calculations. So basically, those are the kinds of learning disabilities that we might think of as cognitive disabilities rather than physical disabilities, which are covered in different ways. So that's just something to give you an idea of the range of disability that students are exhibiting in a school setting. So looking at the history of quote-unquote special education, what we find is that, in fact, the history of taking care of disabilities within school settings is incredibly recent, as we'll see from the dates in just a moment. But basically, up until very recently, special education programs either were separate special schools and classes for children with disabilities, and there were particular focuses on disabilities like deafness, blindness, and mental or cognitive disability, so students with Down syndrome, things like that. Most of those schools were private or residential, and their quality and availability varied widely, and obviously they were not accessible to everybody. The other kinds of quote-unquote special education programs were actually meant to be delinquency prevention programs for what was called at the time at-risk children who lived in impoverished urban areas. And that sounds great, but it's worth noticing that kind of what it was aiming for was dealing with students who were considered to be trouble in some way, usually because they didn't fit into a particular idealized norm of education. And so it's worth pointing out that public education in general, for all of the high ideals that we talked about earlier in the course, they were really created in some cases to bring troublesome others. So I'm thinking here of like waves of Irish and Italian immigration into these correct ways of being and being employed or employable. And so special education had that same goal in some cases. And so that history is problematic. Either it wasn't accessible to those who needed it, or it was being used in ways that penalized certain kinds of people in schools. So this situation lasted for quite some time until in 1954, which may sound like a long time ago, but is really not that long ago. Brown v. Board of Education was decided, and of course we know about that from other contexts. When that was decided and struck down the doctrine of separate but equal, it was because of people determining that racial segregation was problematic. But at the same time, once that decision was made, the parents of children with disabilities realized that, of course, their children too were being excluded and segregated on the basis of difference, in this case, disability. And they began bringing lawsuits against their local school districts, arguing that this practice was discriminatory. As part of this shift, in 1965, Congress enacted the Elementary and Secondary Education Act, and the idea was to address inequality in educational opportunity for quote-unquote underprivileged children, and that was across the board, looking at children of lower socioeconomic status, for example, and that included actual resources. And they amended it a year later to establish a grant program to use those resources in supporting states to develop education for children with disabilities, so specifically saying that this could include children with disabilities. In 1970, the Education of the Handicapped Act encouraged states to continue to develop these educational programs and included, for students with disabilities, including another grant program. Unfortunately, though, neither of those grant programs included any kind of specific mandates on the use of the funds. They weren't directive in any way, and they didn't end up having a significant impact in improving the education of children with disabilities. This finally began to change with two key court cases, which I'll talk about here. The first one was Pennsylvania Association for Retarded Children v. the Commonwealth of Pennsylvania, which is known as PARC. And that case dealt with and sued the Commonwealth of the state based on the exclusion of children, in this case with mental retardation, the term of art at the time, from public schools. And a subsequent settlement of this court case stated that educational placement decisions must include a process of parental participation and a means to resolve disputes between parents and the school. And the idea here was that parents were saying that their children were not being afforded the opportunities that parents themselves felt those children could benefit from, and schools weren't paying attention to that, and that was an important thing for them to do. The next key court case, which was around the same time, was Mills v. Board of Education at the District of Columbia. And this was a court case which spoke to the practice of suspending, expelling, and excluding children with disabilities disproportionately from District of Columbia public schools. And the district said that basically they needed to do that because educating those children was too expensive. So essentially they were using disciplinary methods of getting children out of school because they said they couldn't afford to educate them. The judge in the case, who sided with the plaintiffs, stated that the inadequacies of the District of Columbia public school system, whether occasioned by insufficient funding or administrative inefficiency, certainly cannot be permitted to bear more heavily on the exceptional or handicapped child. So basically saying that is an unacceptable thing, to say that these kids are too expensive to educate and therefore we need them out of our schools. After those two court cases, Congress launched an investigation in 1972. And again, I want to point out that this is not that long ago. I'm not that old. I was born before this, a little bit before this. So this is within my own lifetime that these changes came. And before this, children with disabilities were not being educated properly. So during that investigation, they found that 1.75 million, what they called handicapped at the time children, were receiving no educational services at all. And another 2.5 million were receiving an inappropriate education. So this is millions of children who could benefit from an education, would it be provided to them in an appropriate way, and it wasn't happening. So after this investigation in 1975, then President Gerald Ford signed into law, and this is an important one to know, the Individuals with Disability Education Act, or IDEA, and he signed it into law. It was called the Education for All Handicapped Children Act. And this was a landmark civil rights measure, so it's important to note this was about civil rights, which opened public school doors for millions of children with disabilities by guaranteeing to them what's called a free appropriate public education, or FAPE, you'll see that, in the least restrictive environment, LRE. And the idea was that we don't want to just shunt children away if they don't need it, if they can be in a more mainstream classroom. To every child with a disability in a school district's jurisdiction, regardless of the nature or severity of the disability. And that law has had such an impact, so you think about the numbers before, that by the 2018-19 school year, more than 64% of children with disabilities were in general education classrooms for 80% or more of their school day. That's a huge shift in a relatively short amount of time. Now, we're going to see in a little bit that it's not enough, but it's still an important change. Another important law that has supported disabled students in gaining educational equity is Section 504 of the Americans with Disabilities Act, which was not passed until 1990. So again, I just want you to realize how recent these things are. And that Section 504 says that no otherwise qualified individual with a disability in the United States shall solely by reason of his or her disability be excluded from the participation in, be denied the benefits of, or be subjected to discriminations under any program or activity receiving federal financial assistance. That's basically all schools. There are almost no schools that don't receive some kind of federal financial assistance. So it's worth noticing that the Department of Education's Office for Civil Rights doesn't enforce IDEA. That's enforced by the U.S. Department of Education's Special Education Office, but the Office of Civil Rights does enforce the Rehabilitation Act of 1973 and Section 504 of the Americans with Disabilities Act, as well as the Title II rights of IDEA-eligible students with disabilities. So basically, there are these two federal offices that are working to enforce these laws. And so this is a really important one, and you'll hear about 504s, and I'm going to talk about those more in just a second. So, under Section 504, a free appropriate public education, FAPE, consists of the provision of regular or special education and related aids and services designed to meet a student's individual or educational needs as adequately as the needs of non-disabled students are met. And there's a broad reading of how that might happen, right? So it could consist of education in regular classrooms, it could be in regular classrooms with supplementary services, or it could be like a pull-out special education and related services. So there's a lot of room under Section 504, but the idea is that basically a student's individual educational needs are being met. So who is covered under 504? Basically, qualified students with disabilities who attend a school receiving federal financial assistance, and those qualified students must be determined to have a physical or mental impairment that substantially limits one or more major life activity, have a record of such an impairment, or be regarded as having such an impairment. So how is that defined? So the Section 504 regulatory provision says that a physical or mental impairment is any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following bodily systems. And it lists a whole bunch of systems. And of course, it's not exhaustive. And then it defines major activities, including functions like caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. And that list is also not exhaustive. So basically, they've given a huge range of options that would be included under this. It becomes a very broad law. And it says it's not exclusive and that there may be other things that are included here as well. Okay, so how do IDEA and Section 504 work together or compare to one another? Section 504 is a civil rights law, and its purpose is to protect people from discrimination because of their disabilities by providing access and removing obstacles. The purpose of IDEA was to ensure that all children with disabilities have available to them this freely accessible public education that emphasizes special education and related services designed to meet their unique needs. And it includes students who fall specifically under 13 disabilities listed in the law. So 504 is much broader, and IDEA it relates to a narrower group of students. Okay, so what about IEPs versus 504s? And 504s are called that because they come out of the provisions of Section 504, and IEPs work under IDEA. So they come out of two different laws, and some of you may have heard of both of these or may even have had some of these as part of your education in K through 12. So here's the deal. If a student is eligible under IDEA, fits one under those 13 disability categories, they must receive an IEP. An IEP provides more and might be separate support for students who need help to make progress in school, and it requires this discrepancy between ability and achievement. Under Section 504, a student can also get an IEP. So you could be a student who is eligible for help under Section 504 rather than under IDEA and still get an IEP, which stands for an individual education plan. But that's not the only way to support a Section 504 student. So they could also get what's called a 504 in most schools, which is a different sort of plan. And the goal of that plan is to level the playing field by providing some kind of accommodation. So they may not need nearly as much help or separate support outside of the classroom. This would be accommodations usually inside the classroom so that students with disabilities can participate in school and extracurricular activities. So we'll talk a little more about how student eligibility is determined in a minute, but before we do, it's worth talking about whether the educational level of the student matters in terms of what kinds of accommodations get made, and the answer is yes. So public elementary and secondary recipients of federal funding, which would be basically schools, they're required to provide that FAPE to qualified students with disabilities, and you can see here that description of it, but basically it means that they have to accommodate all students, that every student needs the aids that they need to have the chance of getting their education as adequately as the needs of students without disabilities. At the post-secondary level, read college, an institution has to provide students with appropriate academic adjustments and auxiliary aids and services to give them an opportunity to participate in a school's program, but they aren't required to make adjustments or provide aids that would make a fundamental alteration of an institution's program or impose an undue burden on the institution. So you can think here about, for example, like a nursing program, where it may be that to be a nurse and to meet state accreditation standards for nursing, students have to be able to do certain kinds of physical things or pass certain kinds of math classes, and that it would not therefore be a reasonable accommodation for a student with a specific learning disability around math or with a physical disability that precludes them from turning over a patient, for example. That kind of accommodation might not have to be made. So it's worth knowing that those are very different. The idea here is that students are owed a K through 12 education. College is a little bit different. So as we come towards the end here in the last two slides, I want to talk about some of the places where the high aspirations of these two laws, for all their successes, may not always result in what we hope for. So one of them has to do with how terminations for whether a student is eligible for an IEP or a 504, and IEP is a little more easy to determine eligibility because of the way the law is written, how that determination is made, and or how the determination for what accommodations will be provided, how that is made. So basically, there are many sources which could be used to determine whether a student is eligible for IEP or 504, including a medical diagnosis, aptitude and achievement tests, teacher recommendations, physical condition, and so on. And schools are actually required to look at a variety of sources in making this determination. School districts are supposed to ensure that decisions are being made by a group of people which includes those who are knowledgeable about the meaning of the evaluation data and knowledgeable about placement options. And if a parent disagrees, they can request a due process hearing. So that sounds great. In practice, though, this can be really tricky. So I'm going to talk about a personal example, and I have the permission of my daughter to do this because I'm talking about her educational experience. And I'm talking about it in the context of the Vista Unified School District. My daughter has several learning disabilities, which include dyslexia, a visual spatial processing disorder, and a temporal processing disorder. So she's got these processing disorders, and all of this was diagnosed by a neuropsychologist with a battery of like a 2-day battery of tests, whose results were made available to teachers. And then working with a learning disability specialist, requests for accommodations were made. Now, what's interesting is that in the Vista Unified School District, the actual 504 determination and which accommodations will be given to a student are determined largely by teachers, with the input of a school counselor and of the vice principal of the school. But those determinations are really, it's mostly the teachers who make the decision. And as fantastic as teachers are, most teachers are not educated in reading a diagnosis, understanding it, or in knowing the full range of accommodations that would be useful to a student with a very specific sort of disability. That's too much for teachers. For those of you who are going to be future teachers, you know that's a lot to ask. What we found in this one real world situation was that most of her teachers never actually read any of her medical documentation. We had teachers who said things like, well, it's not like she has dyslexia, even though she has dyslexia. Teachers regularly did not think that she needed accommodations that were being requested because she appeared, quote unquote, too organized in class. So in spite of the fact that the other thing that teachers regularly said was it would not be fair to other students to give her that accommodation, or it would not be fair to the teacher to have to give that accommodation. And what I mean by accommodations are things like putting lists of homework in accessible places in advance, working with her on late assignments, things like that. So interestingly, as this time went on, and my daughter at the time was at Rancho Buena Vista High School in some advanced placement classes, and also getting an international baccalaureate diploma. So by the end of high school, she had done very well on all of her standardized tests, including AP and international baccalaureate tests. She actually received an international baccalaureate diploma, which is no joke, where when her work was being assessed by people who didn't know her off-site, she did fine. At the same time, she was getting D's and F's in most of her classes and almost didn't graduate from high school. So what that says is that when teachers were actually dealing with a student who had trouble turning things in on time, had trouble doing her reading, had trouble with those kinds of things, they failed her in her classes. When her knowledge, her acquisition of knowledge, was being fairly assessed by teachers who didn't know her, she excelled. So, and this is, by the way, is not uncommon in the Vista Unified School District, which has faced multiple lawsuits from parents alleging these same kinds of things and has lost all of their lawsuits. So this is also, this is one of those things where the process isn't working, I guess is what I want to say about this. And that's why I'm sharing this with you. Because when a child's accessibility is determined by teachers who are not trained to do that, then what they fall back on is, in many cases, stereotypes or a lack of knowledge. Some teachers even told us flat out that they didn't believe in learning disabilities. And yet they were the ones determining her accommodations. Furthermore, part of the laws, the 504 law, is what's called child find. It means that schools actually are supposed to be looking for students with disability, determining their disabilities, and accommodating them, but schools don't do that. So what's interesting about this is that there is no long-term way to make schools do that. Even though Vista Unified has lost multiple lawsuits, all they've ever had to do is to go back and give the child who successfully sued some additional help. But of course, by then the damage is done. So this is one place where these laws have fallen down in terms of their implementation. The other place where the laws can fall down is in the area of special education and race or ethnicity. So we know about segregation in schools. We know that about 70% of Black students attend schools where more than half of the students are non-white, while just 13% of white students attend predominantly non-white schools. And this is also true for Latinx students as well. So how does special education fit into this? So we know from research that minoritized students are identified with disabilities at higher rates than white students. And that's what we find when we just look across like aggregated groups. Black students compared to white students, Latinx students compared to white students, so on. But there's been an interesting research study which looks at what happens when you control for socioeconomic status. That is to say, when you compare Black and white students who have otherwise the same sorts of backgrounds. And they did this by a really interesting study in Florida where they looked at 20 years of data looking at birth records so that they could control for other factors, and then looking at disability diagnosis. And what they found was that by fourth grade, the disability rate among Black students was 13% lower than among similar white students, and for Hispanic students, it was 8% lower. And the racial composition of the school made a huge difference. So Black and Hispanic students were placed in special education more often than their peers when they were in majority white schools. But in majority minority, which I hate that term, but quote unquote majority minority schools, they were less likely to be placed in special education. So what that seems to mean is that when students of color are hypervisible because they are in a school that is predominantly white, then they get shunted into special education at higher rates than their peers. But when they're in a school which is probably under-resourced anyway, then they're actually less likely to get the disability education and accommodation that they need. So that's really interesting, and it suggests that this is very complicated, that we wouldn't want to simply say that special education is bad for students of color because we know for a fact that they're getting shunted into those classes and denied access to mainstream classrooms sometimes, because there are other cases where they need those services and accommodations and are not getting them. And so what we need to do is pay attention to context. Context matters. But what this also tells us is that these laws can't be seen as blanket something that can work for everybody in the same implementation, that we need to be thinking about equity and social justice in the application of these socially just laws to ensure that all students are benefiting from them in the same ways to create equality rather than simply the idea of being equal.